Okay, I see it as being 10:45, and so being respectful of our agenda, I'd like to go ahead and resume our webinar. Our first session covered the medical aspects of this COVID reality, and we moved into the regulatory aspects, and now we are moving into the unique issues related to the dynamics of labor and employment issues. And so it is my pleasure to introduce Lynn Sessions as well as Ashlee Grant. They are both partners at BakerHostetler. Lynn Sessions, she focuses her practice on advising healthcare clients on privacy and data security matters. And I see that she is an Aggie, so gig 'em. So also I'd like to introduce Ashlee Grant. She is a partner also at BakerHostetler. And she has been providing guidance to employers in a wide variety of industries on the vast array of issues related to COVID-19. So without further ado, Lynn and Ashlee, you have the floor.
Thank you, David. So I think that we're going to kind of go through the agenda. Ashlee, if we go to the next slide. In the next slide. So we're going to go through the agenda today. These are the things we're going to cover. As David mentioned, you know, Ashlee and I are coming at this coming at COVID from a couple of different angles. My role at BakerHostetler is advising clients, and primarily in the healthcare space, on privacy issues. And we've seen a lot of those come up during COVID, and since, you know, folks have been working from home, and the various issues around diagnosis and what employers get to know about their employees or their family members who may be COVID positive. So we're going to talk a little bit about that and information that has come in, the types of requests that are coming into employers following a diagnosis or a concern of a diagnosis. And then I think Ashlee really has the bulk of what you guys are going to want to hear about. She's been working with a number of clients in the last 6 to 8 months answering these types of questions. And I can just tell you this, if you'll go to the next slide, Ashlee. So I can tell you that because I focus my practice on HIPAA, a lot of the early questions came into me at our law firm about HIPAA. I think there was a lot of concerns, not just from my healthcare clients, which do have to be concerned about HIPAA, but from non-healthcare clients that I think there's just this assumption that HIPAA applies to any medical information that's out there. And that's really not the case. And so very quickly, when my labor and employment colleagues would reach out to me and say, hey, Lynn, we need you to weigh in on HIPAA, my first question every time is what type of entity is the employer? Because if it's not a covered entity, as that term is defined by HIPAA, which is typically a healthcare provider, which I know some of you in the audience are healthcare providers or work for healthcare providers, or a health plan, which is an insurance company that pays for healthcare, then in all likelihood, HIPAA doesn't apply to you. Now, there are some limited exceptions around that, but meaning that there are a lot of employer-sponsored health plans, meaning that the employer, even if it's not a healthcare provider, sponsors a health plan that then has a third-party administrator like a United or Blue Cross Blue Shield or Cigna that administers the plan. So there could be some HIPAA obligations around that. But generally speaking, in this space that we're talking about, unless you're a healthcare provider, HIPAA is not going to apply when we're dealing with COVID concerns. Now, I do take the healthcare provider out separately because there are issues around that if the provider is doing the testing. So a lot of our healthcare providers have set up testing sites, and some universities may also have a student health center that falls under HIPAA, and they're setting up testing sites. And so when you've got those types of dynamics that are involved, then HIPAA might apply, and we have to be concerned about whether a COVID positive diagnosis is given out without a person's authorization. And Ashlee's going to talk a little bit about other laws that are going to apply here, other privacy laws that are going to apply here. Now, I know there's a lot of industrial hygienists and environmental health and safety folks that are in the audience, and I think y'all just heard about the regulatory aspects of this, but we do still have to be concerned about OSHA. So there is a collision of a number of different laws here that either allow for or don't allow for for the sharing of a COVID diagnosis. And then what you guys in the environmental health and safety area have to do then to ensure that the work environment is as safe as possible for the employees when they're either returning to work or those that maybe never did leave work. And Ashlee's going to talk a little bit about those. And so that's really, I just want to kind of tee up that, we hear HIPAA thrown around a lot. I've been contacted by sports teams asking me about how is it that a HIPAA diagnosis a COVID diagnosis could have been made public about a specific player. I've been contacted by politicians, and I've certainly seen it on Twitter, that as people have tested positive in the highest areas of government, like how is that not a HIPAA violation? HIPAA doesn't apply to everything. So there are other privacy concerns we need to be concerned about, and we'll go into those various laws and kind of how they interplay with each other. So Ashlee, I'm going to turn it over to you to kind of get into the nuts and bolts of the employment aspects of this. And then as the privacy issues come up, I'll add a little bit of other commentary around that.
Thanks, Lynn. Hello, everybody. As Lynn had said, I am a labor and employment attorney, and most of my focus over the past 6 to, I guess, almost 9 months, time flies, has really been advising a lot of employers with responses to COVID-19. As far as the questions and issues I'm seeing, really what's coming my way goes with the news cycle. So at first, we were advising people when the shutdown was occurring and decisions related to that. That then shifted to a lot of questions regarding the Families First Coronavirus Response Act. It then turned into questions about remote work. But now, as companies are starting to reopen, as you're having people return to work, that's been the main focus of my questions. And so a lot of the issues I wanted to touch here today are to go over just the general answers to frequently asked questions that I get on pretty much a daily basis and from employers in a wide variety of industries, ranging from oil and gas to restaurants, healthcare clients, even tech industries. But really, we're seeing a lot of the same or similar questions. So first, going to the employee return to work issues. The main questions I see a lot are first, can an employee refuse to return to work? As companies are reopening and starting to have employees come back, everybody's having people, either that are refraining or afraid to come back, whether it be just a general fear of COVID or related to some sort of medical condition or other certain circumstances. So we'll go over that today as well. Next, the idea of high-risk employees. As everybody knows, certain qualities, whether you're over a certain age or if you suffer from certain high-risk medical conditions, places certain people at a higher risk of conducting COVID or more serious symptoms of COVID. Generally, most workplaces are going to have employees that fit within that high-risk category. So a lot of employers are coming and asking, looking out for the safety of our employees, can we prevent those people from coming back? So that's the other question we'll go over here today. Now, first, let's go over, can an employee refuse to return to work? Looking at it the other, the way. You open your doors, you're starting to have people come in. Everybody's probably going to have people that are going to have reservations given how serious the current situation is. The applicable law for most employment aspects that we're going to talk about here is actually not HIPAA, as Lynn has said. It's actually the Americans with Disabilities Act. I think most people are very surprised by that. And that's not just going to govern, accommodations with people coming back. We'll discuss later. That's actually what's going to govern the information you can give in a COVID diagnosis. So it's not HIPAA. It's actually the ADA that you're going to look to here. As far as employees returning to work, the ADA does not allow a general right for employees to refuse to come to work. That applies both to any employee as well as employees with disabilities. There's no outright refusal, even in terms of the current pandemic, that would allow them to just simply not come to work. That being said, when you have employees who express reservations and express fears to come to work, and they have a disability, the EEOC's guidance that has stressed over and over since the beginning of COVID is that employers really are encouraged and obligated under the law to engage in what they call the interactive process, and so determine what appropriate reasonable accommodations you can provide to allow the employee to continue to work. Sometimes telework may still be the appropriate accommodation, But sometimes you may be able to come up with accommodations that would allow the employee to come to work and also would, ensure their safety in the workplace. Some examples that, we are seeing are, the shields, the guards that you see for cashiers, the plates in front of cashier windows, providing someone with a closed office door, staggered office shifts, in addition to telework. So while someone may just refuse to return to work completely, they may not necessarily have that right, but you've got to at least engage in an interactive process and determine, if you can figure out a way to have that employee return to work or return to some of their duties, and give them some sort of accommodations if they have a disability. Now, I will say one question that we're seeing a lot is an employee doesn't have a disability, but they do have a general fear of coming into work. They're worried that if they come in, or the more interactions they have, the more they go out in the public, the greater chances of contracting COVID-19. As I said before, that there's no general right to refuse to work, and just a general fear of contracting COVID-19 does not give that employee the right to just refuse to come back. Again, they've got to, in order to even trigger that interactive process, you've got to have some sort of disability covered under the ADA. Now, we're seeing more and more with the rise of the quarantine, just a lot of the stress and emotional stress this is taking. Some of those general fears may actually be a disability such as anxiety or other mental health issues. And so, be aware of I'm scared may not trigger the interactive process, but if someone comes in and says I'm scared and I have anxiety and they're able to provide that diagnosis or medical information to support that, they could then, you could discuss that interactive process. And that may be a situation where telework or another accommodation would suffice. But overall, just say, I don't want to come in, I'm too scared, or I don't want to contract COVID for my safety. Under the law, then that doesn't cut it. You can still require them to come back. Now, another question that we're seeing is when you have an employee who has family members, whether it be a child with a certain medical condition, people who are caregivers for their parents or other elderly family members, or even spouses, maybe, for instance, that have certain medical conditions. And so what if an employee requests, can I continue to telework, or refusing to come in because of a family member or someone who lives in their household? Under the ADA protects the employee. It only covers the employee's rights. And so there's no legal right under the ADA to grant an accommodation or to allow that employee to continue to not come to work because of a condition or a disability of a third party. So in that instance, that's not a reason that would allow them to refuse to come to work. That being said, in all of these instances, there's an overall recommendation by the EEOC and even the Department of Labor, the Department of Health and Human Safety, every government organization is still encouraging people and encouraging employers to have employees telework and work from home when and where possible to avoid the spread of COVID-19. But again, as we're opening up, and also just, telework is hard in certain circumstances, that's where these instances are going to apply. Next, we've got kind of the alternate issue where you may have certain employees who want to come back to work, or you've got employers that are eyeing opening their doors, but you've got a group of employees that fall within this high-risk categories. So you've got employees above the age of 65, and you have people that are suffering from certain medical conditions that have a greater exposure to more serious effects of COVID-19. Under the ADA and ADEA, which is the Age and Discrimination in Employment Act, you cannot prohibit someone from coming to work simply because of their age. So if you have an employee that's over the age of 65, or in this case, the ADEA covers anybody over 40, but if you have an elderly employee who wants to come to work and has not requested not to come to work, you cannot refuse or prohibit them from coming. You can't put them on leave. You can't cut their hours simply because they place in a high-risk category, even if it's for benevolent reasons. Even if obviously you're trying to look out and keep your employees safe and healthy. But unfortunately, if the employee wants to come to work, that is not a reason. Your good-hearted reasons still are not going to count. You've got to let the employee come back to work. And the same comes to employees with medical conditions under the ADA. The ADA's triggers only come in the instance where the employee asks for an accommodation. If they don't request one, you don't have to take action. It also is not going to allow you to just exclude that employee because of their medical condition, similar to the age. So it's one instance that I'm seeing a lot where you're seeing employers really wanting to look out for their employees, but under the law, that actually could be a violation. Next, we're seeing a lot of, okay, we're opening our doors, someone tests positive, what do we do? And so I've got a number of questions, just kind of step by step, the issues that employees are facing. So the first one, what now? What do we do? The first answer is, I think, the most obvious. If the employee is at work, you send them home. You also then require them to quarantine for a certain amount of time that we'll go over today and not report to work in accordance with CDC guidelines. Also, you're going to have to next investigate. And by investigate, what we mean is figuring out two things: who and where. So the who is, who did this employee in the past 7 to 10 days have close contact with? And by close contact, that's governed by the CDC guidelines, which is within 6 feet of distance, so within close proximity for 15 minutes or greater. As far as how do you determine the who, I've seen it done a number of ways. If the employee is someone you've talked to on the phone, asking them, obviously, who have you been around? Who have you talked to? We're having employers that have apps. For example, our firm, we have a QR code. So when I go on a floor, so that automatically limits, they see the floor I'm on, and that limits, they can figure out at least a group of people who fall into that. And then you can figure out by asking the person. Employee checklist. So when an employee walks in the door, there's a bunch of different ways to figure out the who this person may have had contact with. It's in your way, your own kind of social figuring out who they have. The other issue I've seen, we've had instances, what if the employee is non-responsive? They're in the hospital. How do you figure out who they've had contact with? What I have seen in those instances is either, looking at who's in their workspace and who was in the workplace that day. So, looking at time cards. I've even seen people go to measures as extreme as looking at video. So figuring out the 7 days before where that employee went. That is a bit on the extreme side, but it's also the most cautious way to make sure you're accurately figuring out who needs to be notified. The other issue is the where. So finding out where this person was. What parts of the office? Were they in their office? Did they go to the break room? What about restrooms? Where on the floors if you've got a multiple floor facility? So figuring out who they had contact with and what parts of your facilities they did. The next thing you're going to do is coworker notification. And this is where the ADA, and Lynn in particular, comes into play that we get a lot of questions about. So for coworker notification, you are encouraged to notify those people who were in close contact with this person that they have potentially been exposed to COVID-19. However, under the ADA, you are prohibited from identifying that person specifically unless that person has given you permission. So, and if they have given you permission to disclose their identity, you can of course say, Ashlee Grant has been diagnosed with COVID and you had close personal contact with her. We encourage you to not report to work and to self-quarantine for the 14 days prescribed by the CDC guidelines. However, if I had not given permission to release my name, you are not allowed to disclose that. And instead, the employer would have to give the information of you have been in contact with an employee who has been exposed and may be exposed to COVID-19. The question that where this seems to people come up, a lot of people say they have a right to know the person's name. That is not true. Unless the person gives you permission, you cannot disclose that information. The other issue we're seeing is sometimes it's obvious. A lot of times it's going to be incredibly obvious who the person is, especially right now where you have very limited openings. Where you've got only 5 or 6 people coming into the workplace, where you've got, at a certain time or even at all. Yeah, while the ADA prohibits the identity, we can't prohibit deductive reasoning. That being said, you can't confirm. So, if the person in the office next to me, or if I only had contact with one person and they figure out it's me, they could figure it out. But if they, when asked, was it Ashlee, unless I gave permission, my employer could not confirm or deny it. It's the typical lawyer response of I cannot confirm or deny that. But again, the key thing here is whether or not the person actually gives you permission to disclose their identity. I think what I'm actually being surprised and finding more often than not is a lot of times people are giving that permission. But other times you'll be surprised and it's not. But that's the key thing to remember. And I also remember it's the ADA. It's not HIPAA that's prohibiting this. The next step is cleaning and disinfecting all of the areas where the person had contact with. So it was the investigation, the who, now we're to the what. The cleaning needs to be done in accordance with the CDC cleaning and disinfecting guidelines. One thing to note under those guidelines is that if the employee has not been to work for 7 days, then you technically, you don't have an obligation to clean and disinfect. That being said, part of the state guidelines and even reopening protocols still require you to clean regularly touched areas on a consistent basis. So keep cleaning, keep disinfecting. And the next is the employee benefit information. So you have an employee who is sick, they cannot return to work, they've got to self-quarantine. They may be symptomatic and still have to self-quarantine. Always give that employee the information on their leave benefits, PTO. In certain instances, they may be entitled to leave under the FFCRA, which is the Families First Coronavirus Response Act. That's a mouthful to say. So providing them the information to cover their time off. One thing to keep in mind is that the EEOC, the Department of Labor, the CDC, OSHA, everybody is recommending that employers become more flexible in their leave policies. Allowing more time than usual. Because what we're seeing is that if employers are not allowing time off, even if they're not required to by law, that's going to encourage employees who may not have time off in their leave banks to come into work or to not disclose a diagnosis, which then could result in a breakout in the workplace. So being flexible in your leave policies and giving the employees the information on what they can do in their time off is always the next step. And then also being transparent. One of the things that we're seeing is the less information you provide, obviously without respect to the identity issue. But when employers are very closed off, are not giving information, that is where employees are getting worried. They're being fearful to come to work, and they're also raising complaints. So letting people know that you've cleaned and disinfected this area. It's also going to make your employees feel reassured and feel safe. The next question we have is, do we have to pay the employee while they're out? And the question is, it depends. I keep throwing out this FFCRA. So if any of you on here have less than 500 employees, you may be obligated to provide that employee with paid emergency sick leave with up to 80 hours. So please keep in mind that. But the one thing I do want to put on everyone's radar is it almost seems reverse, because most employment laws are designed for bigger employers. But if you are over 500 employees, you are not obligated to provide paid leave under this act. Next, the question of when can an employee return to work? It's all governed by the CDC guidelines. Since we're running close on time, I'm just gonna put them up here. So it's gonna depend, it's either at least 10 days since the first symptoms, at least 24 hours since the resolution of a fever without medicine and the other symptoms have improved. And for asymptomatic employees, it's 10 days since for the first positive COVID test. One thing to keep in mind that employers are asking a lot about is you are encouraged by the CDC and the EEOC to not require a doctor's note or proof of a negative COVID test to allow them to return to work. Instead, the CDC guidelines of when an employee can exit isolation are what's going to govern. I'll also note that there are a couple municipalities and cities in Texas that have orders right now that explicitly prohibit employers from requiring either a doctor's note or a negative COVID test. Dallas actually is the one that comes immediately to mind. So in their return to work protocols and their COVID-19 emergency orders, it specifically states that employers cannot require employees to either provide a doctor's note or a negative COVID test to return to work. The issue with this is because, as I'm sure many of you on here know, is because of the influx and just extreme amount of work on healthcare providers, having this extra requirement of having employees come in and wanting a doctor's note, doing that extra test with the shortage of tests, it's just really going to put a strain on the healthcare facility and the healthcare industry, which is why these government agencies are encouraging people to not require that. Now, the one question that I have that I've been getting a lot recently is, can we be sued? So can we be sued if an employee is exposed to COVID-19 or thinks they were exposed to COVID-19 in the workplace? Or the alternative is, we have an employee that came in, they're sick now, are we going to be sued by their other employees? That is a question that's still in the works. Right now, a lot of states are coming out and saying that more than likely, in this instance, it's going to fall under workers' comp, which means you're subject to the liability caps that come with workers' comp. You're also subject to the actual procedures in the workers' comp procedure as opposed to an actual lawsuit, which, yay for employers, I think, that's a good cap. The other issue I wanted to raise is that right now in the second stimulus bill, one of the items that's always been up for debate in Congress is an employer liability provision. So right now the Republicans are trying to push for a law that would limit or outright prohibit employer liability, except in the instances where there's willful conduct by the employer or just a gross neglect of following COVID-19 restrictions or putting restrictions in place. It's still up in the air. Of course, we're probably going to see very soon an influx. We're already starting to see them of lawsuits arising from people who are getting sick and claiming it's from the workplace. But as of right now, it looks like there's either going to be some sort of statutory limitation, which some states are passing, or the ruling will likely fall that it'll fall under workers' comp. A couple just outstanding random questions. We're getting a lot of questions now because you hear about the vaccine. Can we require employees to get it when it comes out? In general, that answer is going to be yes. You can implement mandatory vaccination programs. However, there's going to have to be exceptions for religious and health accommodations. Can we prohibit or restrict employees' personal travel? That's going to depend on the state, but in Texas, technically, yes. I will note that's very difficult to enforce. So what I advise is do the opposite. Instead of a restriction, have it be a requirement that they disclose. And then when they disclose, you have the policy of them quarantining if they come into work. The other reason it's hard to implement is just because of all the various areas whose numbers of COVID are influxing and changing. And then finally, can we have our employees sign liability waivers? This is a new one. As of right now, the answer seems to be yes, so long as you meet the requirements of a valid waiver. That being said, there's always the chance that someone's going to argue that the waiver is unenforceable. This is kind of a wait and see, but most of the legal analysts think that yes, as long as you actually meet the requirements for a standard waiver of liability. So that's all we've got today. Any questions?
Fascinating presentation. Thank you, Lynn and Ashlee. As we wait here, if there are any questions, I've got one question on the paid 2 weeks. What can an employer require that an employee provide evidence that they've been advised to quarantine before they're required to pay for those 2 weeks?
Yes, there is certain notifications, requirements that you have to give to show that you're eligible for leave. And it's usually in the form of a questionnaire, but yes, employers are entitled to ask for that, look under the statute, and the ADA also states that you're allowed to ask the employee for that information.
Very good. All right, any other questions?
And again, if you have questions, please type those into the Q&A box.
Okay, I don't see anything pop up. If anything does, Please, if you do have any follow-up questions, please put them in here and we'll do our best to follow up on those questions that are entered.